A debt collector sends you a letter. Federal law gives you 30 days to write back and demand proof that the debt is yours. Send that letter, and collection is supposed to stop cold. But what happens when they simply ignore it? Here is the part most people never hear. A collector who keeps collecting before validating is not just being rude. Under the Fair Debt Collection Practices Act, that conduct is the violation itself, and the law gives you a specific way to answer it. Section 1692G gives the clock a precise start, the collector's first written notice about the debt. Not the day you borrowed, not the day you defaulted. You have 30 days from receiving that notice to dispute it in writing. One detail decides everything. The demand has to be in writing. A phone call may create a record, but it does not trigger the pause the statute describes. Put it on paper and mail it inside that 30-day window. Once that written dispute lands, Section 1692B says the collector must cease collection until it mails you verification of the debt. Not a summary, verification. When they send it, collection can legally resume. Until they send it, it cannot. So they ignored you and kept calling. From here, your case is only as strong as your paper trail. Certified mail with return receipt proves they received the letter. The signed green card proves the date. A dated call log proves what came after. Think of it as two columns. One proves they received your dispute. The other proves collection continued anyway. A judge reading those side by side sees the entire story in a few seconds without needing you to explain the statute first. Next, put it on the record. You can file a complaint with the Consumer Financial Protection Bureau and with your state attorney general. Neither one awards you money, but each creates a dated third-party record of how the collector behaved. Now the remedy. Section 1692K allows statutory damages of up to $1,000. Read that carefully. It is up to $1,000 per lawsuit, not per violation and not per phone call. 20 calls do not become $20,000. The statute stacks 3 categories. Statutory damages capped at $1,000 per lawsuit. Actual damages, meaning provable harm like lost wages or bank fees. And court costs, plus reasonable attorney fees if the court finds a violation. 3 numbers run this entire process. The collector must send that written notice within 5 days of first contacting you. You get 30 days to dispute. And under Section 1692 Quad D, you have 1 year from the violation to file suit. Because the statute shifts costs and reasonable fees onto a collector who loses, many consumer attorneys take these cases with no money up front and get paid from the award. That is not a guarantee of any outcome, but it is why a small claim can still find a lawyer. You have 2 doors. Hire an attorney who handles debt collection cases and let the fee-shifting provision carry the cost. Or file in small claims court yourself, where the filing fee is modest and you argue straight from your paper trail. Both are legitimate. Whichever door you pick, bring 3 things. The collector's first written notice, your certified mail receipt showing they received your dispute, and the log of every contact that came after that date. That sequence is the entire case. One honest caveat: none of this erases a debt you actually owe. Validation exists, so the amount and the creditor are confirmed before anyone pays. If the debt is verified and it is yours, the obligation still stands. Know the sequence: their first notice, your written dispute inside 30 days, their silence, your documented paper trail, and 1 year to act on it. That is the fine print, and it is yours to use. Know your money rights.